Have you ever made a decision because you genuinely believed it was the safest thing to do for your child? A decision made in fear, a decision made under pressure. Now imagine being told that despite your intentions, despite everything you were trying to do to protect your child, the law may not automatically agree with you. For many parents, that is one of the most painful and confusing realities of international family law. Welcome back to Asking the Expert, Understanding Family Law, Child Protection and Child Well-Being. I'm Arielle, lawyer, researcher, and mother. Today, I want to talk about why a parent can genuinely believe they are protecting their child and still face legal challenges. It's life-changing. Most parents do not wake up looking for conflict. They are trying to do their best when they feel frightened, isolated, or unsupported. As parents, our instinct is often simple. Protect first. Figure everything else out later. Emotionally, that makes sense, but legal systems work differently. One of the hardest things for parents to hear is this: the court cannot automatically act on fear. The court has to act on evidence. Now, that does not mean the court ignores concerns. It means that courts need information they can assess fairly and objectively. If someone says, "I am worried about my child," courts want to know, what happened? When? Was it reported? Who witnessed it? Is there evidence? Decisions that affect families need to be based on evidence rather than assumptions. This helps ensure outcomes are fair and informed. Imagine a mother living in another country. She believes the environment has become harmful. She feels frightened and decides to leave for her home country. From her perspective, she is protecting her child. From the court's perspective, they ask for medical records, police reports, or messages to assess risk. The court is not necessarily saying the parent is wrong. They are asking, how do we assess the situation fairly and objectively? This is often misunderstood. Judges cannot see inside your mind or base decisions on what they hope is true. They must use testable evidence. That is why documentation matters. That is why records matter. That is why process matters in these complex cases. One of the biggest mistakes parents make is believing that a genuine concern automatically becomes a legal justification. They are not always the same. Courts still need to understand what happened, what evidence supports the concern, and what alternatives existed at the time. These questions are not designed to punish parents. They are designed to help courts make decisions that are fair and truly informed. Courts look for records of events, communication between parents, medical reports, and evidence of when concerns actually arose. The more information available, the easier it becomes for a court to understand the full picture of a family's situation. One thing I've learned is that family law cases are rarely just legal cases. Behind every document is a parent. Behind every hearing is a child. That is why these conversations matter. Understanding the legal process before a crisis occurs can make an enormous difference for a family. Lesson 1. Protection and legal strategy should work together. Acting to protect and understanding consequences are both vital. Lesson 2. Keep records. If something concerns you, document it carefully. Memories fade, but documents remain. Lesson 3. Seek advice early. The earlier you understand your options, the more choices you usually have. The law does not ignore children's safety, but courts must balance concern with evidence and protection with process. Understanding that balance is key. Join me in the next episode as we explore what judges really look for in child abduction and custody cases. I'm Arielle, and this is Asking the Expert, because understanding the law can change lives. This content is for educational purposes only. Every family situation is unique.